Hi everyone, welcome back to the GoodLaw Solicitors YouTube channel. I hope you're all well and thank you for clicking on this video. Today's video we'll be answering the most frequently asked questions about mediation. We've got our mediator here called Jane Wells and we've got our paralegal in the family department here, Sam. So I hope you enjoyed this video. If you do, smash a huge thumbs up, and other than that, let's get into it.
So Jane, tell us about yourself.
Hi Sam. Well, I'm a family mediator and I'm also an associate, senior associate at GoodLaw, so I basically specialise in family work.
First questions is, what is family mediation?
Basically, family mediation is an alternative process for parties who are in the process of separating to be able to discuss in the presence of an impartial third party how they want to resolve the arrangements involving their children, involving their separation, and the aim of the mediator is to basically assist them in reaching a resolution and avoiding a court process and avoiding having to deal with matters through solicitors. I'm not saying they don't need solicitors, they need solicitors to take legal advice, but the aim of the process is that they discuss it with the mediator and the mediator explores options with them, and hopefully if they're able to resolve matters in mediation they're able to reach a final agreement at the end of the process. So that's really what family mediation involves.
So does a mediator then have to be a solicitor?
No, there are mediators out there who are counsellors, other professionals. In fact, anyone can actually be a mediator, but I would certainly recommend that if you're going to mediation, that you get a mediator who has been properly trained as a family mediator, and there's a number of associations that offer mediation training, and also to be a member of the Family Mediation Council. At GoodLaws, we are lawyer mediators, so our backgrounds are as lawyers, and the benefit of that is that we can provide legal information to our clients, having obviously that experience. But mediators can come from all different backgrounds.
So within mediation, a word we hear thrown around a lot is MIAMS. Do all parties have to attend MIAMS, and how would you describe what MIAM is?
Right, I think MIAMS is in fact an information meeting that mediators can offer clients, particularly when clients are wanting to attend or take their matter into court. Most clients would have to attend a MIAMS in order to make an application to the court. And the aim of that is that to ensure that they've been offered mediation and considered that process. MIAMS is in fact a meeting the mediator will have with a party individually. MIAMS should take place with both parties individually, and both parties should be offered to attend a MIAMS. So it's a meeting to provide information about a number of processes that are offered, alternative dispute resolution processes, and also mainly if I did a MIAMS, obviously we'd be talking about our process, the mediation practice that we offer. And really it's to ensure that clients have information about the process, can ask any questions. There's also a screening for domestic abuse and child protection that's undertaken during that process. And the meeting normally would take place either remotely or it can be in person, and it's really an information gathering process so that the party can decide, one of the clients can decide whether or not they think mediation is something they'd like to do. And if it's not something that's suitable, the mediator will make that decision. But if it's not suitable, then the mediator will be able to sign what's called a MIAMS form to say that mediation isn't suitable. And that form would need to be provided to the court when they put in an application.
So if there's been domestic violence in a relationship and a couple that have come to mediate, will mediation be suitable for them?
It is very dependent. When I undertake the MIAMS meeting with the parties, it's part of my screening process, is to ascertain whether there's been any domestic abuse. And domestic abuse incorporates domestic violence, incorporates physical abuse, sexual abuse, financial abuse. It takes into account all those aspects, and the important thing for a mediator is to be absolutely satisfied that a party is able to freely mediate, and if any of these types of domestic abuse are present, It's not to the extent that mediation really wouldn't be suitable. So that's why with the meeting that we have, the MIAMS meeting we have, is quite an extensive meeting. It's at least between 45 minutes and an hour, so that the client has that opportunity to share anything with the mediator. As I said, it's a confidential meeting, so it's not a meeting that's disclosed to the other party. So there are circumstances where if a party has suffered domestic abuse or domestic violence, that you can mediate. But the most important thing is that the mediator does screen that and is satisfied whether the case is suitable. And that's the mediator's role, and it's up to the mediator to decide whether mediation is suitable, not the client's. And the mediator will make that very clear after this MIAM session, that she will decide or he will decide whether mediation is suitable in their case.
So what if you've got both parties, they're willing to mediate, they go along to some mediation sessions after a MIAM? What happens if that mediation breaks down?
If the mediation breaks down, then the mediator will be able to sign a MIAMS form to say that mediation has broken down, and then that form is included in the application to the court. So if they decide to take the matter to court, then the court will know that mediation has broken down. So that's really the process. And some mediations are successful, some break down. The only thing I would say in relation to that is that some people come into mediation and say they want to just try a session. They're not sure it's going to work. And the important thing is that they've had that opportunity to mediate. And even if they've managed to have 2 mediations and it's broken down, in my experience, it can be a very helpful process, even if it doesn't get to the final resolution, because it's enabled them both to sit in a room together to try and resolve those issues. And some issues are resolvable and some aren't.
We mentioned earlier about domestic abuse, and I just heard you mention there about a couple might be sat in the same room. So if there has been domestic abuse and there might be a need for safeguarding measures within mediation, what sort of safeguarding measures are undertaken by a mediator?
When the mediator has the first interview with the clients, which is the individual confidential meeting, if they're concerned that there has been domestic abuse in the relationship, but it's the client and the mediator feel this is a case that could be suitable for mediation because there's not actual fear of violence continuing in a relationship. Some relationships there could be an incident of domestic abuse, if we're talking about perhaps domestic violence or some sort of threats. They can happen very much when parties separate, and then it's a one-off incident. The mediator, as I said, has to screen to decide whether it's suitable. But there are safeguarding measures the mediator can talk to the client about, them attending, coming at an earlier stage and the parties being in separate rooms before the mediation starts, leaving separately. So there are ways that can be done. But the most important thing is the mediator to be satisfied that this is a safe process for both parties. Because the most important thing in mediation is that if they do reach a resolution, it's because they've been able to engage and reach it without those sort of fears, really, at the end of the day.
Would someone, in your experience, bring along a solicitor?
It's unusual to have a solicitor in mediation. There are circumstances when solicitors may be invited to mediation, but it's highly unusual. The aim of mediation is you don't have a solicitor present, and the solicitor's involvement is outside the mediation. So a client has every right to obtain advice from a solicitor outside the process, and the mediator would certainly in our practice we would strongly advise that they do take legal advice, because the mediator can't give legal advice. They can give legal information, but they can't give legal advice.
In your experience with mediation, how many sessions does it take, or roughly how long does it take?
It very much depends. The sessions that we offer are usually an hour and a half, no more than that they tend to be, but in some circumstances parties are travelling quite far away or want blocks, then we can arrange that. Every mediation is different, but they tend to be an hour and a half. The number of sessions that you would require for mediation, it depends on obviously the issues that you're going to be talking about. I normally would give a sort of estimate. So if I'm talking with parties about issues around their children only, I would say between 2 to 4 sessions of mediation. If we're looking at financial issues, then I would say 3 to 6 sessions. But this isn't cast in stone. The most important thing is that mediation should not be rushed. Certainly in my experience, those cases where a party comes in and just wants things dealt with very quickly, they just don't stick. So the important thing is it goes at the pace of the clients. So that's an average. And at the end of every session, the mediator will ask the clients, if they want to continue with mediation, they feel difficult to say one way or other, they can always confidentially tell the mediator by email if, or correspondence, just to say if they feel worried about mediating. But one of the important things with mediation is that it's a process that involves all three of the parties, so basically the two clients and the mediator, and that there's no communication that's not basically, it doesn't involve, everybody has to be involved in all communication when mediation starts. So there's no separate communication between the client and the mediator. Satisfied, the mediator's neutral, and that's really important for clients to understand that.
So if through the process of mediation a resolution is reached, how's that often communicated to the parties?
So if a resolution is reached in mediation, the parties are invited, the mediator can inform them that we would provide a written document to confirm the resolution that's been reached, which is called a memorandum of understanding. And then that written document is without prejudice, it's not legal and binding, and that document will be provided to the clients, and they can then pass it on to their solicitors. And if they want it to be a binding agreement between them, then the solicitors will prepare a binding agreement, either a consent order or a binding contract or whatever. But that's how it's communicated. Some clients don't actually want a document. They might, so the mediator would probably, certainly in our circumstances, I would prepare a sort of an outcome sheet of what we've agreed in mediation. So at least they've got something to take away with them.
And in the unfortunate situation a resolution isn't reached, what sort of happens then?
Well, as I said, if a resolution isn't reached, then the parties will have the opportunity to speak to solicitors and take the matter to court. And as I've said before, obviously they can get a MIAMS form signed.
So how much does it cost when you want to come to mediation?
We've got details of our costings on our website. We have a legal aid contract for mediation. So when I have a MIAMS meeting with the parties, with my clients individually, I would assess whether they may be entitled to legal aid. It's really only there for parties that are on very low incomes or on benefits. It's offered for parties that are on universal credit, but they also, their capital and property have to be within the guidelines. So I would assess that in the first meeting. So legal aid's offered. If they are eligible for legal aid, then the mediator would have to fill out a form with them, and they would in fact get all the mediation sessions free. If what the other party isn't on low income and isn't entitled to legal aid, then they would have to pay for the process, unless we're dealing with children issues. And then there's a voucher scheme that the Ministry of Justice are offering at the moment, which is £500 towards the costs of mediation. It's only in children issues. And the other thing that the clients will be informed is if one party is entitled to legal aid and the other one isn't, they will get the first session free. Everyone will get the first session free. Again, that's something that the government are offering. So all this information will be provided in that first session. As far as our mediation costs are involved, the details are on the website.
So if a couple have come to you and one of the big concerns they're mediating about are child arrangements, can the mediator meet the children, and how can the children's wishes and feelings be present in the mediation sessions?
Mediators can meet children, not all mediators. They have to have basically intended a course with a mediation service to be able to show that they've had the relevant experience to be able to meet with children. So there are certain mediators that can do that, and it has to be very carefully done, and both the parents have to agree to it, the children have to agree, and it's done in a very careful way. And the meeting with the children isn't a meeting in which the mediator will say to the children, what do you want to happen? It really is the mediator just explaining to the young people or the children to say, that I've been mediating with your mum and dad, and we just wanted to know if there's anything you want to say. And it's really to allow them to have a voice if they want to have a voice, and to allow them to share information if they want to or if they don't. So the parents need to understand that if the mediator does offer that service and they want to take that on, that the children may not want to share anything with their parents. And that's a confidential meeting between the mediator and the children. And in my experience, as I am able to undertake those sort of meetings, is that it's very powerful, the children are very insightful, and they do really want to say things. But it's not always appropriate, and it's certainly something that the parents both have to agree to. If that's not going to take place, then in order to ascertain the children's wishes and feelings, the only way the mediator can really do is to find out from each of the parents how they feel their children are managing the process and get the information in that way. So it is something that only certain mediators are able to do because it has to be done properly.
Last question. What are the benefits of mediation and why would you recommend it?
We're going to be discussing this in a further video, but very briefly, I would say that mediation is something that is of benefit to separating parties. It is a process that they own, so they come into mediation and the aim of it is that they discuss the issues they want to talk about, and any resolution they make is a resolution that they've made together. It's a process that we put the children at the forefront, so if there are children involved, then they become obviously at the forefront of our discussions. And it avoids going to court, it avoids having solicitors involved in quite lengthy litigation. It's also a much cheaper process, but that shouldn't be the reason for mediation, but it is certainly a process that is certainly cheaper than going through litigation. And we will discuss that in a further video at a later stage.
So that is all our frequently asked questions about mediation. I hope you enjoyed this video. As Jane mentioned, stay tuned for our upcoming video of what the benefits are of mediation. I hope you enjoyed it. If you did, smash a huge thumbs up like I said at the beginning, and I will see you in our next one. Bye!